Hello, everyone, and welcome to Let's Be Honest. I'm your host, Just Johnda, and I am so excited to start this new season off with one of my Just Johnda's LBDs. So I am really excited. So tonight, we are going to jump right in because there is so much that has been going on lately. We have the case of we have the case of the violinist versus the men in black, which I'm going to get into. Very interesting case. So this is starting a series under the LBD called High Profile and High Stakes. So this is the first one. I'm going to preview some of the other cases that we're going to talk about because they are coming fast and loose. So we're going to jump right in. First things first, I will be talking about the Stefan Diggs case. We also will be talking about one that just broke today, the Donnie McClurkin case. And the Stefan Diggs case, I'm going to touch on probably at the end of this. But I definitely wanted to begin this by getting into the case involving the man in black, Will Smith, because this case, I specifically called it peculiar because it is definitely different in terms of what he did, what he didn't do, what he knew, what he didn't know. And that's why I asked those questions in the description for this, because I do think that there's a little bit more to be explored. Now, a lot of times when I do these cases, I read straight through, and I am going to do that so that you have the real deal on what it's about. And we're going to stop and we're going to talk about it. If you have questions, certainly post them so that I can see them and respond, and even perhaps even bring certain comments up on the stage. So we are going to do that, and I want to be interactive with you so that I can see what's going on with you and what you need to know. That being said, I like to start by talking about what the causes of action are in the case. What are they suing for, right? Because we look at these cases, we're like, well, John, what the hell are they suing for? So if we start out by looking at what they're suing for, you can keep it in the back of your mind when I read the facts. Okay. So again, if you have any questions, let me know. I love for this to be interactive. This is kind of a serious one, so we may not get many of the jokes out of it because you guys, those of you who have been watching me, you know I love to laugh. I know I like to make this very basic and understandable for anybody who's watching, but it is a little serious. So let's first start with what the person is suing. So what this person is suing about. So the person who is suing Mr. Smith is a young man named Brian King Joseph. Now, Brian King Joseph is a violinist, very talented young man. He probably came to at least international eyes as all seeing him because he appeared on America's Got Talent. I thought it was American Idol, but it's actually America's Got Talent. And so, as we will see as we go through the case, through a series of circumstances, he also came to know Will Smith as well. So, at a certain point, Brian King Joseph did end up as an employee of Will Smith, his companies, his management. We'll get into all of that because he ended up going on tour with him. So again, I want to talk about the causes of action before we get into the facts, because I want you to keep in mind that at its core, this is a case that is very much about an employee-employer relationship that may have turned, well, for wanting a better word, maybe a little icky. So there's that part. And then, of course, we will talk about the fact that outside of the employee-employer relationship, there also may have been bad actors or bad behavior on the part of either the management company, or Will Smith himself. So again, please keep that in mind. So the causes of action, there are several. Most relate to retaliation. So you have several of them, because when it comes to employment law, you've got the labor codes that are localized to that area, as well as the state laws, including. So we have retaliation as it relates to the labor code right there in California. There's a second cause of action related to retaliation. There is a third cause of action related to the termination, because you can have a retaliation claim just because of how someone was treating you after some event, but they didn't necessarily fire you, but they were still treating you in a way where it was clear that it was based on something they felt that you did them wrong. And in this case, this young man is saying that it was in large part because he reported bad behavior, and we're going to get into that. There's also another violation under the Bain Act, which specifically deals with retaliation in the workplace because of safety hazards. And again, when we get into the facts, you'll see why that was a safety hazard issue. Then we have the Ralph Act, which still all under that employment law, but now we're talking about alleged violence or intimidation or threats of violence related to the person's sex or their sexual orientation. And finally, we have the sixth cause of action, which is the alleged, well, we're on YouTube, so sexual harassment, for one of a better way of putting it, and that's under FEHA. So there's that one, and I think that that's the one that a lot of people in reading this case have gotten really stuck on, as opposed to the employment stuff, which gets a little confusing. That's the one that a lot of people have really stuck on, and I think we're going to spend a fair amount of time on it too, because I think that's where the most questions come into play about what Will Smith knew, didn't know, did do, didn't do. That's where I think a lot of people are getting hung up, and understandably so, because as we'll see when we get into this, it's not really clear what it is that he's alleging that Will Smith did specifically. So let's get into it. So this case was brought in Los Angeles County. That's where Will Smith's company is. I believe that the one big incident that he talks about, they were still in LA, I think, but we'll come to that at that part of the case. So the parties, who's suing? We talked about Brian King Joseph. He is the person who is suing. And then who is he suing? And we've seen this in other cases. A lot of defendants, because especially when you're dealing with entertainers, and certainly big entertainers, you've got their management, the production company who was in this case running the tour. Sometimes the person actually owned the production company. In the case of Will Smith, based on even the name of it, Trey Ball Studios Management, we know that this is his production company in conjunction with other people. And then they will also sue unnamed parties because their attorney may not know. It gets a little crazy when you have all of the layers. Okay. So I see it there. Hey, Shade in the City. Yes, you're recording, Patone, but I'm glad that you are listening. So again, ask any questions you like in the comments. So we know who the parties are. Venue and jurisdiction, they're saying, is in California, mainly because that's where the production company is. That's where some of the transactions arose, including him actually being hired. And again, I do believe that the hotel incident may have occurred there as well. But again, we'll get there. So what are the allegations? You're like, Just Johnda, we have been on for 11 minutes. What the hell is this person saying that he did? Well, I'm going to get into it now. Okay, so plaintiff, in this, I'm going to read straight through and then I'll jump in and again, ask any question you like. Plaintiff is a professional violinist who became employed by defendants in connection with a high-profile live music tour as a touring musician and crew member. So for those who may or may not remember, because you may or may not have gone, I'm leaning towards a lot of you with not. Will Smith was on tour probably about a year or so, well, maybe several years, a couple of years after the infamous Oscar incident. Remember, he put out a CD maybe a year or so later. Remember, the following year, he had a song with gospel artist Kirk Franklin, and they performed it at one of the award shows. I believe it was probably the BET Awards. So that particular song that some of you may have seen him perform was a part of an entire project. And then he went on a tour. No, it wasn't a big, Beyonce sized, zillion city tour. It was just a limited tour. Maybe he was feeling it out to see how it went to determine if he was going to do something more. But anyway, out of that rabbit hole. So, following studio sessions with several high-profile artists, plaintiff, and the plaintiff, just to remind you, is Brian, the violinist, and I may call him the violinist sometimes instead of just plaintiff to remind you, was referred to by the defendants for a potential recording opportunity. Two representatives for defendants contacted the violinist about coming out to Smith's personal residence for an introduction. So essentially, some of Will's people saw this young man. He was in the studio with others, and they're like, we think he might like you. You might be a fit for what we're doing. In or around November 2024, Omar provided plaintiff. Omar is one of the individuals who works for Will Smith. He provided the violinist with Smith's address where he met Smith and showcased his talent on the violin. At this same meeting, Smith invited him to join him at an upcoming performance in San Diego. So, hey, I'm going to try you out right there on stage with my fans. Let's see how it goes, which was set for December 2024 and ultimately to join Smith as part of his global tour. And let's see. So, based on a true story was the 2025 tour. In or around December of 2024, he performed at the San Diego show, and the invitation that they talked about did come. He was asked to do more performances, and he said that Smith expressed to him that he was a valued member of the group and slowly provided him with additional stage time and features for the show. So, for a young budding artist, it sounded pretty good, right? So thereafter, Smith invited him to play on several tracks on the upcoming album. So I guess the album wasn't quite done, but you get the point. He had a project and, he's testing it out. And it sounds like they were doing the album in conjunction with the tour. He said that their relationship grew even closer. Smith and the violinist began spending additional time alone, with Smith even telling him, "You and I have such a special connection that I don't have with anyone else," and other similar expressions indicating his closeness to the plaintiff. Could be some artsy fartsy stuff. Who knows? But again, that's what he claimed. That's what's in the complaint. Let's see. He invited him to do the tracks. Okay, so Section 20. Following a 2-month break from the December performance, plaintiff was provided with the documentation and touring information for the global tour. The tour would span over several months, and plaintiff was provided with a full schedule for the upcoming performances. By the way, if you see me looking off to the side a little bit, it's because I actually have the complaint right up on my screen as I'm going over it with you. So, following a 2 month break, okay, we talked about that. The tour would be all over. In reliance on the upcoming tour, the plaintiff advised Smith's representatives that he would be spending thousands of dollars for additional musical equipment, medication, and other necessities for the upcoming tour. Sounds reasonable. You got to get ready, you got to go. Okay. In or around March 2025, he joined him for the first leg of the tour, which was in Las Vegas, Nevada. So actually, this incident we're going to talk about, it was in Las Vegas. But again, all the contracts were signed in California. So I think the venue still sounds legit. At any rate, he joins him on the leg in Las Vegas in March. He says that the defendant, now again at this point, when he's saying the defendant, because there's several, is he saying it was Will Smith or the production company? Because again, it would seem a little odd that Will Smith booked the rooms himself. But hell, I don't know. We don't know his life. Maybe he's got that much time on his hands. So, defendant booked rooms for the plaintiff, the rest of the band, and crew members, with each individual's room number and confirmation code being sent on a spreadsheet for the cast and crew. So, it looks like everybody on the cast and crew, if this was on a spreadsheet, everybody knew everybody's business, at least for the purposes of who's sleeping where. No other individuals besides for the crew and hotel staff would have had access to plaintiff's personal room. That's an interesting statement as well, especially given what we're going to get into, because are you leaving it open? And I would, as the attorney, I would have wanted that sentence closed a little more, because you're saying that they had access to this room. You're kind of opening it up to say that any of these umpteen people could have gotten in and out of your room. Better stated, it probably should have said everybody knew each other's room number. And the reason why I'm saying that is because if you are trying to imply that certain specific people may have done what you are alleging was done to you, or this intimidation tactic, which we're about to get to into the next couple of sections, you kind of left it open for a huge swath of people to a door for folks just to walk right through. It's the defense attorney in me peeking at that. At any rate, plaintiff's bag, which contained his room key, was left in the van responsible for transporting all cast and crew members of defendant's team around 11 a.m. when plaintiff and crew were dropped off at the venue for rehearsal. Again, open for pretty much anybody. I mean, it's certainly cast and crew. Plaintiff requested that management retrieve his bag at 3 p.m., at which point management indicated that they were unable to find it. So we already know things are starting to go downhill. My bag's missing. And if his bag had musical equipment or meds in it, I would be going off. I'm sure he would have too. At 5 p.m., management returned to plaintiff with the bag, which contained his key. On or about March 20th. So let me go back. So this says in or around March, doesn't really say what day. So we're not really sure if this is the same day, because there's no date given for when he arrived to Vegas. They just said early March. So again, these are like little things that I like us to keep in mind. I always like to say that I have the smartest listeners and viewers everywhere, because we get into it, right? So on or about March 20th at around 11 p.m., while staying at the hotel in Las Vegas for a scheduled performance with Smith's tour, plaintiff returned to his assigned hotel room and discovered evidence suggesting that an unknown person had unlawfully entered the room. According to hotel security, there were no signs of forced entry into the room, and the only individuals with access to the room would have been part of defendant's management team, who booked the room for him. This information was documented by phone calls between the plaintiff, and we're still talking about the young violinist, and hotel security. Let me check. Any questions? No, we're good. Okay. The evidence included a handwritten note. So now we're going to get into what was the indicia or the indicators that someone had potentially been in his room. Here's the evidence. The evidence included a handwritten note addressed to the plaintiff by name. Creepy, I agree. Which read, Brian, I'll be back no later than 5:30. Just us, a drawn heart, comma, stone F. I'm going to read that again in quotes. I'm going to read it exactly the way it is. Brian, comma, I'll be back no later, probably meant to put than, but didn't, no later, 5:30, comma, just us, they drew a heart, another comma, stone F. Very weird note. Among the remaining belongings, none of which were his, remember that, these are things that he found. Among the remaining belongings were wipes, a beer bottle, a red backpack, a bottle of HIV medication with another individual's name. They don't indicate the name here. An earring and hospital discharge paperwork belonging to a person unbeknownst to the plaintiff. It doesn't make clear that the individual's name on the meds and the hospital discharge paperwork were the same individuals. I think we're going to assume, just for the sake of shits and giggles, that it was a different person, because why wouldn't you say so if it was the same? Okay, so we'll just make that inference. We could be wrong, but we're going to do it anyway. Plaintiff feared that an unknown individual would soon return to his room to engage in, again, we're on YouTube, sexual acts with the plaintiff. Now I'm going to stop here for a second, just because I think this is where the interplay of sexism really was a real factor. Because as a woman, and any women listening, we get that if we found something like that in our room, nobody would have any issue with us being up in arms, with us losing our absolute shit if this was found in our room. And if we immediately jumped to the conclusion, and I am not saying that in a negative way, if we immediately jumped to the conclusion that someone had some sexual intent towards us, that we were in danger of some type of assault, as women making that report, nobody would blink that we immediately jumped from finding a pile of weird crap on our bed to thinking there is somebody out here to do me dirty in more ways than one. And I think that we have to keep that in mind when reading this, because there shouldn't be, and I've seen some things, so I know that there is, and people making fun and go, why is this a big deal? Nobody actually did anything to him. I think that we need to keep that into perspective, because if it would be, no one would blink for a woman to draw that conclusion finding these things. Nobody should blink for a man finding these things. And the only reason people would say, oh, well, is because he's a guy. And that's just not fair. Because to say that this is just, if true, because again, these are his allegations, we don't know, right? We just know what's written here. But if taken as true, this is freaking disturbing. I mean, let's just call it what it is. It's effing nuts. Okay, so let's go on, on my soapbox, bum. Okay. Concern for safety, and shout out to one of my favorites, Spill It Boy, who does that as well. We got to get off the soapbox and go on to the next thing. So I'm give him a shout for that. Concern for safety and the safety of fellow performers and crew, plaintiff immediately notified hotel security and representatives for Smith, because again, those were his employers. So You absolutely, he did the right thing. You contact the hotel people, but you also contact the people you're on tour with. For all you know, this could literally be happening to everybody. So he contacted them, he contacted security representatives, he obtained photo documentation, he requested a room change, and he called the local non-emergency police line 311 to report the incident. Again, all makes sense. And as I've already said, and I want you to keep in mind, nobody would think that any of these moves were unjustified if this was a woman or a young girl. Plaintiff reported the event and followed all instructions he was given by the management team. So apparently the management team also gave him instructions. He filed a written incident report with hotel security. He communicated with hotel management and offered to provide all information to the defendant. Okay, no problem there, right? I mean, this is crazy. He made clear that his only concern was safety and he did not wish to receive any special treatment or compensation. Okay, uh, that's reasonable. His room got changed. I can't imagine the hotel kept him in the same room. And as we know, people get moved for less than that, right? My shower's acting up. Change my room. On or around March 21st, so the next day, he traveled back to Los Angeles to support the cast and crew for a pre-recorded show. So at this point, it was legit that they were all leaving. Nothing, no allegations that anybody was taking anything out on him. However, he was told by Tim Miller that it was too late to enter through the crew entrance and that they would see him in New Mexico just weeks later for the next leg of the tour. Okay, I'm sure his hackles went up a little bit, but you didn't say I was kicked off the tour. I might feel a little some kind of way, but that I flew here, but let's hope he didn't pay for the flight. On or about March 23rd, so now we are 3 days from the original incident, 2 days from him not being allowed into the pre-recorded show. He reached out to Miller to speak about the next leg of the tour. Okay, so Miller told him next leg of the tour is in New Mexico. I'll see you then. Legit. I'm reaching out saying, okay, probably what's up? What's the arrangements? On or about March 24th, he spoke with Miller, so we're going to assume he didn't speak to him on 23rd, during which Miller began blaming him for the incident that transpired on March 20th. Okay, remember what I said the claims were. That's why I started out that way, because now as you read it, you could start plugging the facts into the holes of the claim. So now we're filling in the pieces of the puzzle. I gave you all the edges of the puzzle, the claim. Now we're filling in the pieces, and we're going to go over the claims again. But I hope you're filling it in while you're reading. I'm sorry, while you're watching, or if you're listening to this on the pod. Okay, so rather than being protected against further assault, these are their words in the case. Now we're at paragraph 37. Rather than being protected against further assault and for attempting to understand plaintiff's complaint, plaintiff was shamed by defendant and told that he was being terminated. So defendant, in this sense, we're going to presume he's talking about Miller, because Miller, being a part of the company, falls into the defendants. And let me double check to see if he was named separately. He was not named separately, but again, one of the parties, if you will, because he did name the company, Will Smith particular. One of the companies is the management company, and they use the words here inclusive. So you are also suing any of the fictitious names of the company, any of those, and anybody who works for the company, because at this point you represent the company. So if I'm suing Trayball Management and you represent Trayball Management, I'm suing you too. Or your actions are going to be attributed to the management company. So no, the money, if he gets money for this, wouldn't come from Miller, but Miller's actions would be taken into account as the actions of the company. No different than pretty much any of us. Okay, so we were at 37. Okay, so now 38. When plaintiff requested, okay, so he said he shamed him and told him he was being terminated. So ding, ding, ding. Remember we talked about retaliation claims. When plaintiff requested for further reasoning, Tim Miller, acting on behalf of defendant, remember those key words, redirected the blame for the termination right back on to the plaintiffs, replying, I don't know, you tell me, because everyone is telling me that what happened to you is a lie. Nothing happened and you made the whole thing up. So tell me, why did you lie and make this up? And why would you just automatically assume that he did that? And again, that's not to say, because we've seen how women are treated. So that's not to say that a woman wouldn't be treated the same way. But I have to wonder, and that's a good reason for him bringing the claim that we're going to talk about again as it relates to sex or sexual orientation. It does lend itself towards him rightfully raising the question of whether or not he was treated this way because he was a man. And although I don't know anything about his sexual orientation, there are probably assumptions that others have made, people that he works with, as well as anybody who has seen him in the video he posted as it relates to that. So, draw the conclusion, it's, if you will, from what I'm saying without saying something that he hasn't said to me himself. There you go. So plaintiff, shocked at the accusation, had nothing further to say and felt as though the reports, evidence, and turmoil from the night before spoke for itself. Now, well, several nights before, as we know. As requested by Miller, plaintiff submitted evidence and a timeline of the events that transpired on March 20th, 2025, attempting to explain the traumatic series of events that occurred that evening. So now at this point, let's face it, he's gaslighting him. Miller was completely screwing with him. Again, we're saying if all of these allegations are taken as true, he was screwing with him. If I already fired you, why am I asking you for more stuff? Defendant never made any effort to verify if the safety concern was true or not. One call to the hotel security would have been sufficient. Instead, defendant was intent on firing plaintiff because he reported the attempted sexual assault. Miller also indicated that now attempted sexual assault might be a bit of a leap, but again, in fairness, we can understand, as I already said, so I'm not talking out of both sides of my mouth, we certainly understand why, given the items that were left, one would feel that if you were in danger, it would be of a sexual nature. Miller also indicated in person and via email that the tour was moving in a different direction, which was part of the reason for plaintiff's termination. Real convenient. However, following plaintiff's report and termination, defendant hired another violinist to assume the same position on the tour. This hiring strongly suggested that defendant's stated reason for the termination was pretextual. And I believe that I either read or heard somewhere that the new violinist that was hired was like a white woman or something, but that I stand corrected if that's not true. And I'll double check and put it in the notes later if that's incorrect. Plaintiff further pleads on information and belief that defendant's conduct goes beyond a mere failure to protect an employee's safety or a dispute over a claim. The facts strongly suggest that defendant Willard Carroll Smith, because we know Will Smith's name is Willard, Carroll Smith II, was deliberately grooming and priming Mr. Joseph for further sexual exploitation. So this is where we make the jump. It's just in time for that last claim. It's this one paragraph that to me undermines so much because it lends itself to a couple of things. It lends itself to people jumping to the money grab assertion without and of course conveniently ignoring everything else in the preceding paragraphs. And of course it undergirds a whole salacious thing because as soon as you say certain celebrities' names as it relates to sex, and even more so a situation involving sex that may be of, shall we say, a more prurient nature, whether that is same sex or, let's face it, Will and Jada have been accused of so many things, both individually and as a couple. So this paragraph 42, lends itself to that salacious part, as well as, for me, even if I were to ignore the whole, gossipy, salacious stuff, which we all love too. And, again, no hypocrites over here. It kind of undermines things a little bit because I think that it went somewhere that it didn't have to go, especially when we talk about the grooming piece, because at the time you were not a child. You were two musicians who were vibing. When you went to his house and he liked the way you play, oh, come on tour. Yeah, I'm a vibe. You're a vibe. You're going to be on my upcoming project, all of that. Did you think at that point that there were actually passes being made towards you? And again, I don't say this to victim blame or any of that, because everything up until this point, I'm a card carrying member of the Violinist Club as it relates to everything up until this point, because that whole room thing, and then if that firing went down the way they said it did, Will Smith and his management company, they've got some problems. You could you can leave paragraph 42 in there if you want to. I mean, it's not like, the judge would throw the baby out with the bathwater just because that piece sounds a little goofy. But that other stuff, it doesn't sound great because it came a little too close to the incident. And again, if what the violinist is saying is taken, or Brian is saying is taken to be true, the Miller, mentioned the incident during the firing. If you were going to fire him, even if you were doing it to be retaliatory and dead wrong, at least try to make your wrong look right. Don't give the person evidence for the shit that you're doing while you're doing it. If you're going to say we're getting rid of you because the tour is going in a different direction, we're doing something different, we just don't think you're a good fit, we were kind of just, dragging you along with us because we were hoping that things would gel. Will likes you, but the crew, the band, blah, blah, there's a million things that you could say, especially since he said it, they were going in a different direction. But the minute you mentioned that incident, you gave him his case. I mean, obviously there's lots of legal wrangling, but I'm just saying you gave him something to chew on for sure. Okay, so let's see. The facts strongly suggest defendant Willard Carroll Smith II was deliberately grooming. So overused right now because grooming is a real thing. For those of you who have listened to me before, you know the type of work that I do and have done over the years. So I take these things very seriously, and of course, to coin a phrase that's used a lot, but it is true. Words mean something. We know that people like to just use random words because they sound good. People love to throw around gaslighting like it means everything that people says it does, and it doesn't. And the same thing when it comes to grooming. In this case, they're talking about grooming and priming. Just problematic to constantly be throwing around those words. Again, if there's something else that went on, hey, he certainly will. He's certainly gonna have to bring it, and if he does, we'll talk about it. But just within the context of this, kind of hokey. Doesn't throw. It doesn't mean that the other stuff isn't true, but just it's the thing that make you go, bro. I was with you, and now I'm like, Okay. The sequence of events, Smith's prior statements to the plaintiff, and the circumstances of the hotel intrusion all point to a pattern of predatory behavior rather than an isolated incident. Okay. And I get it. In the age of post Weinstein, current Diddy, you get in the hotel rooms and random objects, no baby oil this time, but just weird stuff. And then, of course, let's not forget the infamous case of the, oh my gosh, his name I did an episode, I did several episodes about it previously. The gentleman who ran for governor of Florida. He lost. That election was stolen from him. And I think right now he has a podcast with, who's that podcast with? Is it What Happened to Kate Williams? Might be. But at any rate, remember he was found butt naked on a hotel room floor, and there were pills scattered around and vomit and all kinds of stuff. It kind of sounds a little bit like that case. It is going to drive me crazy that I can't remember his name, because that case was a good one. Okay, so defendant's actions caused plaintiff severe emotional distress, economic loss, absolutely, reputational harm, because, people talk, we get it, and other damages. Plaintiff was also harmed as a result of the stress of losing his job. His health, as a result of losing his job, his health deteriorated, causing major physiological damage, although they talk about emotional distress, so I'm sure when he gets in the court, has his day, he'll say psychological harm. And he said he suffered from PTSD. That would be psychological harm, and other mental illnesses as a result of the termination. Now, this paragraph is someone who, in addition to the other areas of law that I do, who have done personal injury and other types of civil suits, this is the language that we're going to toss in no matter what, because when you ask for damages, you actually have to talk about how you were harmed. And of course, unless somebody punched you in the face or chopped off an arm, then most of the damages, besides economic loss, obvious, are going to lend itself to the soft damages, almost like soft tissue injuries in a, in a personal injury case. And that would be talking about PTSD, talking about emotional distress. This is nothing you all haven't already heard in other cases. I am going to take a drink because obviously I've been talking too much, and I don't have my handy dandy water bottle sitting next to me to sip on my straw. I'm trying to cover up the label on the water. I'm not advertising for anybody unless you're paying me. Okay, so let's get back into these causes of action, and then we will wrap up because we're not going to go over an hour tonight. And we're going to do some clips of this, and I am going to jump in since it's not too late. I am going to go live again after this, and I'm either going to go live or I may record it, but either way, I'm going to jump right into the Stefan of it all. So you'll either see that later tonight or that'll drop tomorrow. Okay, so our first cause of action. Now we'll dig a little bit deeper into these causes of action that I talked about a little briefly. See how we did that? We came full circle. So it's retaliation and violation of reporting sexual harassment. Okay, so this is retaliation specifically because he reported it, because and that's what is so cool about a lot of these new laws, and it's a good thing, they're needed, is that it allows you to sue even if the retaliation didn't get to the point of you actually being fired, but you are at the job still being treated like absolute crap. And there's no question that it was, well, of course, people are going to say it's a question, but it just happened to conveniently come after you reported sexual harassment. And of course, there's retaliation for many things and many causes on the job. But as we know, sexual harassment is a whole class unto itself. Because let's face it, up until not too long ago, certainly in my lifetime, people didn't care. That wasn't a thing. It was like on the books, but nothing ever happened with it. So I actually remember the Clarence Thomas, Anita Hill hearings. Okay, so retaliation and violation of reporting sexual harassment in FEHA government code, code section 12940H. So this is against all of the defendants, because again, whoever did it, even if it's Miller that was the one who brought down the hammer, you're the representative for the company in that instance. So you are taking the company down. And the crazy thing is that if he wins, that's not the person who'll end up paying the money. Now, the smart money might be on him potentially losing his job, but that doesn't always happen either, because you were just being a company man at that point. So plaintiff incorporates by reference all of the allegations. So that's just simply saying everything that we alleged, consider it in this particular instance. And we're going to see that over and over again. So you're just reading a lawsuit primer 101. Okay, so that particular code says is illegal for any employer, labor organization, employment agency. So we know all the things, or other to discharge, expel, or otherwise discriminate against any person. So remember, guys, you don't have to be fired. If you think that you are being discriminated against, even while you still have the job because of a situation like this or others that we'll talk about, there's still a cause of action at play. Now, it may, who knows, the retaliation could get worse because you still actually work there, but the cause of action is there. Okay. And so back to what it is. So discharge, expel, or otherwise discriminate against any person because the person has opposed any practices forbidden under this part, or because the person has filed a complaint, ding, 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 testified, or assisted in any proceeding under this part. And again, in any proceeding. So we're not saying that you filed a complaint against them, but they may have felt that it made them look bad, obviously. Plaintiff was an employee of defendants working in California. The defendant took an adverse employment action against the claimant, the plaintiff, so they're using it interchangeably, by terminating his employment as the tour's violinist for Smith's Global Tour. Among other things, his employment was terminated because he opposed practices that were forbidden, which is essentially, as he said, him being sexually harassed. Now, we are going to, there's a little something from a defense standpoint that I'm going to finish reading this, but there may be a little something that the defense has as it relates specifically for this. Not retaliation generally, but specifically for this. Plaintiff's complaint of sex-based harassment was a substantial motivating reason for the adverse employment action. Defendant removed plaintiff's previous role as the tour's violinist for the next show in Los Angeles and then effectively terminated his employment from the tour altogether. Plaintiff was harmed. Defendant's decision to remove him from the tour and end his employment altogether directly caused plaintiff's harm. As a direct and proximate result of the acts of defendants, as alleged above, plaintiff has suffered humiliation, mental and physical distress and anxiety, and has been generally damaged in an amount to be ascertained at the time of trial. The acts of defendants, and each of them were undertaken for improper purposes, as alleged above, and were willful, wanton. I love that. I love using this whole sentence. We all do. Willful, wanton, deliberate. It's not wontons like we eat. Wanton. I was reading it too fast. Deliberate, malicious, oppressive, despicable, in conscious disregard of plaintiff's rights, and were designed and intended to cause, and did in fact cause, plaintiff to suffer economic damages, physical pain and injury, and substantial emotional distress and significant PTSD, and therefore justify the awarding of substantial, exemplary, and punitive damages. Now, that was a hella long sentence, but a good one, and had some of my favorite words. It also makes me think of a line from one of my all-time favorite movies, and one of my one of the favorite lines in movies, 9 to 5, when you use all the big words in a row. And for those who are old school, you remember that they called Dabney Coleman a sexist, egotistical, awful, something hypocritical bigot, but it was great. And I'm going to come up with it at the end, but it was great. And Dolly and Jane kept repeating it over and over again. So did Lily Tomlin. It was great. So back to this. Okay. I made a 9 to 5 detour. Okay. So defendant's conduct described here and was engaged by managing agents for a defendant and or ratified by the managing agents. So that again is just making sure that we constantly remind the court that we know that Mr. Smith himself may not have physically been in a room or physically said these things, but he, of course, is someone who we should make sure takes the blame for it, and his company take the blame for it. So that's part of the reason why they did that. So we'll make sure that, so they'll make sure of that. Now, I did put a little pin in it, where I think the defense may have an in here. Where the defense may have an in here is the sex-based harassment at work piece, because their defense, because they got to come up with a way to defend this. This is not to say that when we get into the other retaliation counts that he might not have them dead to right. I'm just talking about this one because this retaliation count is tied to not only him reporting it, but that the alleged sex-based harassment was, we're going to say, even though it says at work, as counsel, I would argue that implies that it was related to his work. Therefore, there is the implication being made that it was someone connected to the tour. So this harassment being related to us, you haven't met that burden of proving that bizarre incident in your room was committed by any of, for want of a better way of putting it, the cast and crew of the Smith Global Tour. So if that incident, while you may have reported it, and as we'll get into in the other counts, that report may have been what led to us firing you, which again would be retaliation. For this particular count, we would argue that you need to meet the initial threshold of proving that someone related to us did that to you. So this alleged sex-based harassment that you're alleging, you haven't proved the sex-based harassment. You haven't proven that Mr. Smith has been anything but gracious to you and enjoying your music. You haven't proved that he actually groomed you. And you certainly haven't proven that anybody connected to us were the ones who put the items, my hair is getting all in the ear, who put the item in your room. So to me, that would be the best way for them to attack this one. The retaliation, that's a different animal. And again, if that meeting with Miller alone, if the court finds that he is credible and believes him over Miller, then, because of course Miller is going to say, I don't say any of that. If that happens, then he's got the retaliation counts. But again, you got to try and win what you can win, so that the court doesn't, if this doesn't settle out of court, which it might, if this doesn't settle out of court, again, in trying to win what you can win, you got to try and knock out as many counts as you can, because what you don't want is for the plaintiff, if you're the defendant, you don't want the plaintiff to get an award associated with every single count that they bring, because as we know, that adds up. Even if we're dealing with small numbers, you got 6 counts and somebody gives you $100,000 on each of them. Well, now we're at $600,000. So if you can at least get rid of 3, you're at $300,000. You with me? You with me? Okay. So the next one, now this one is just retaliation without the sexual element. So everything I just said was specifically because that first count it had the sexual harassment piece to it. So once again, incorporates everything by reference. Now, in this one, this particular account, it says is unlawful for an employer to retaliate against an employee for disclosing information. Doesn't matter what the information was. Or because, like whistleblowers, essentially. This is a great, I don't know if this is California's version of a whistleblower statute, but that's what I would call it in this instance. Or because the employer believes the employee disclosed or may disclose information, if the employee has reasonable cause to believe that the information discloses a violation of state or federal statute or violation of a non-compliance with local state or with a local state or federal rule or regulation. So there's actually 2 pieces to this. Let's see what he says that violation was, because if he still sticks with just the sexual harassment piece on this, I think it's the same problem as the first cause of action. So let's see. Plaintiff hereby claims that defendants discharged him in retaliation for engaging in protected activities when he reported unlawful conduct during a work tour. Okay, he did. Someone breaking in his room would be unlawful. Defendant was plaintiff's employer at the time of the retaliation. Plaintiff complained about the illegality of such conduct to defendant's employees or representatives, and by doing so, engaged in a protected activity. So it's not saying, at least not yet, that the defendant was the one who did the illegal activity, but I did report illegal activity, which would be someone breaking in my room and, scaring the crap out of me. Defendant discharged the plaintiff. We know that. Plaintiff's protected activity was a contributing factor in defendant's decision to discharge the plaintiff. As a direct and proximate cause of defendant's acts, or as alleged above, plaintiff has suffered humiliation, mental and physical distress, all the same things we talked about. And again, we're going to just say that the defendants and each of them and their acts were undertaken for improper purposes as alleged above, and were willful, wanton, deliberate, malicious, oppressive, despicable, in conscious disregard for plaintiff's rights, and were designed and intended to cause and did in fact cause plaintiff to suffer economic damages, blah, 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 blah. So we know that paragraph is going to be in each one. This one, it gets us more in the ballpark because it's not focusing on sexual harassment. I think this one where the defense will, because we know what the plaintiff is saying. So I'm just giving you, because what the plaintiff is saying, what they're saying. So I'm giving you the defense, please. In this one, I think where the defense will have an in is to talk about, again, not so much the fact that you weren't potentially fired, but you got to meet both pieces of that statute. Not just that you were allegedly retaliated against by being fired, but that and by reporting information, but the information that you report, you have a reasonable cause to believe that it discloses a violation of a state or federal statute, or a violation or non-compliance with local, state, or federal rule or regulation. So I know that's a lot of words, so I'm going to make it simple. You can't just say, I was fired because I disclosed something. The nature of what you disclose is important too. Okay? So for this particular statute, the nature of what you disclose has to fall within that definition I just gave you about what kind of information it needs to be, which is the potential law violation. So that's where the defense has an in on that, because the question then becomes, what is the law violation? Now, of course, they'll say someone broke into my room and tried to threaten or intimidate me with what was left. And that's not to say that that isn't significant, but it leaves room for the argument. Okay, so that's the second cause of action. The third cause of action, retaliatory termination and violation of public policy. Now, this one is where, because it's very broad, he's got a little bit more meat here. Okay, and now I'm talking about the plaintiff. So again, all the things are still alleged again. So paragraph 66, at all times relevant to this complaint, it has been the law of the state of California to prevent retaliation against employees who complain about workplace health and safety violations. Now, this is a good one. See, his attorney, he was on his stuff. Okay. It's unlawful for an employer to terminate an employee when the discharge of the employee contravenes the dictates of public policy. Plaintiff claims that he was discharged from his employment with the defendant for reporting conduct that violates public policy. So let's talk about it. What was that policy? Public policy. I am sorry, I made my screen a little small. Okay, there we go. Okay, so let's talk about what they claim the overall public policy was. Leading up to the time of discharge, he was employed by the defendant. We know that. He engaged in a protected activity by reporting the trespass of an unknown intruder into the hotel room booked for him by defendants, and who had made sexual assault threats at him while he was on the job. Now, again, we understand why he feels like it was that. So we don't want to just ignore what was left in his room, what the note said, the HIV medication. That is not only creepy, but under any circumstance, why wouldn't somebody feel like it was threatening? Even if you can't really say, well, that was a direct threat towards you, it felt threatening. And the note did allegedly say Brian. So I think that this one definitely has he's approaching the place where, from the plaintiff's standpoint, his attorney was in his bag. He was like, okay, I'm gonna give you 1 and 2, but he's getting a little bit more in his attorney's getting a little bit more in his bag with this one. This is somebody who definitely practices in this area and knows exactly what they're doing. Nice building blocks on this one for this particular for the counts that we're getting to, including this one, because now you're just talking about public policy. Now we're just talking about it's very broad. Like you, so people aren't supposed to report when they're being threatened. So is that what we're saying? That's what we're doing out in these streets. So a protected activity, wouldn't that be reporting potential harms or threats? Someone trespassed in your room? So good stuff there. And of course, we had this. So we said the plaintiff's protected activity was a substantial motivating reason for his discharge. And as I said earlier, Miller, as he claimed, Miller wasn't smart enough to just say, we're firing you because we don't like the way you play violin anymore. He also mentioned the incident and mentioned him filing that report, accused him of making it up. That him filing the report would be the protected activity. So this is a good one. And again, we have the same stuff there about the harm that it caused him. You always got to restate the harm. This Bain Act violation. So not everybody has this. This Bain Act violation in violation of Civil Code Section 52.1. Once again, incorporating by reference all the other stuff that we've said. Now, the plaintiff has the right under the laws in the Constitution of the state of California to report safety hazards in his workplace and to be free from retaliation for doing so, including rights protected by California codes, particularly the other codes that we've already mentioned. And of course, he mentions the California state constitution's guarantees of personal security and safety. Again, like I said, his attorney was in his bag on these. Okay, so following the unlawful entry by an unknown person and the leaving of personal items in a note addressed to plaintiff in his hotel room while employed by the defendants, we've all agreed, creepy, jerky, crappy, should definitely report it. Scary, let's call it what it is, scary. Not going to just say it's creepy because this guy's scary. I'm a woman, that's crazy. Plaintiff exercises rights by reporting the incident to hotel security, filing a written report, contacting defendant's management, filing a report with them, and requesting that appropriate safety measures be taken. Following these protective actions, defendants, through their agents and representatives, again, because no word that Mr. Smith was in the room, engaged in threats, intimidation, and or coercion by abruptly terminating plaintiff's employment, falsely stating they were moving in a different direction and replacing him with another violinist. So this would be, it doesn't sound like threats, but it certainly sounds like intimidation for sure. These acts were intended to and did cause a plaintiff to reasonably believe that if he exercised his rights to report workplace safety hazards or demand a safe working environment, defendants would take adverse employment actions against him, including termination of his livelihood and damage to his professional reputation. And we know that they did actually fire him, but I could certainly understand because the business is small. The circles are small, certainly at that level. Will Smith is a huge star. He is a global superstar. And although we may not be racing out to buy his CDs or to go to his tour, he is still one of the most famous people in the world. I mean, that's just the long and short of it. And, you know, despite the slap heard around the world, what he would say about someone would carry weight. What his management would say or his company would say about someone would carry weight. You being on this tour and suddenly dismissed and people either not saying anything or you feeling like it's not a good look. So it all makes sense in terms of feeling when they talk about adverse employment actions. The adverse employment actions lead itself more towards the reputational harm and adverse employment actions as it relates to him continuing to work in an industry that is very incestuous in terms of what people say and how it can impact your career, especially people at the highest levels. And you just don't get much higher than people like Will Smith, even if this was on the music side versus what he's most famous for in current day, which would be the acting side. He's still Will Smith. So all of that made sense. In the alternative, defendant's termination of plaintiff was a retaliatory act intended to punish him for exercising the above rights and deter him and others from engaging in such protective activity in the future. So defendant intended to provide plaintiff of his enjoyment of the rights and interests protected by California law, including the right to report workplace safety hazards and to work in a secure environment free from retaliation. All makes sense. Plaintiff believes that Will Smith himself was involved in the decision to terminate the plaintiff. Possibly, but again, even if he wasn't, it's his company, so you're still screwed in that regard. If this is found in his favor, but it all flows up to the top. Okay, so the Ralph Act violation. So this is the one regarding sex and sexual orientation. At all times relevant, plaintiff had the right under California Civil Code to be free from violence or intimidation by threat or violence because of his sex and or sexual orientation, whether actual or perceived. So I was right when I talked about that earlier regarding the sexual orientation and the actual or perceived. And I think it's because he knows what people assume about him based on the way he looks or based on the way he speaks, etc. We're all, well, I hope mostly adults here. We know the deal. We don't have to call it to know what it is that people might think. And in this case, use what you got to get what you want. Since you do know that is, your existence every day in terms of what people may think or say when they see you, and somebody's trying to screw you over, well, I'm tossing that in there too. I'm not mad at it. No different than if these were white people that were at the top of the totem pole in this, and you're black, you toss in the sexual orientation, and you'd probably toss in race too. And I'm not saying that it wouldn't be legit depending on the circumstances, but I definitely get it, especially in this case, because we also know, let's again not pretend we don't know the implications for someone who people may perceive things about their sexual orientation and just happen to leave HIV meds in the room. The implication is, it's like implication on top of implication, and you get enough of them, it's like, okay, come on, who's zooming who here? So not grooming, I said zooming. Going back to that eternal sage, Aretha Franklin. Okay, so while working for defendants, anyway, while working for defendants, plaintiffs returned to his hotel room, assigned and arranged by defendants, and discovered evidence of unlawful entry and an individual's personal belongings and evidence of a sexual threat of violence. The intrusion into plaintiff's hotel room was a violent and or it looks like there's a little grammar thing here, but so I'm going to read it the way it is, but this isn't the way I speak. The intrusion into plaintiff's hotel room was a violent act. Okay. And or, all right, I got it. And or intimidation by threat of violence against plaintiff's person. Okay. I'm going to read that again because I tripped my own self up. The intrusion into plaintiff's hotel room was a violent act and or intimidation by threat of violence against plaintiff's person and property and in a sexual nature. Okay, guys, it's like after 11, and even though I'm a night owl, I'm still not usually up reading to people this late, especially when I had to leave for court at 8:30 this morning and drive an hour and a half. Okay. The circumstances, including the personal nature of the items left behind, the note addressed to the plaintiff, and prior statements by Smith to plaintiffs, such as, "You and I have a special connection." Okay, for those of you who are listening as opposed to watching, I'll just explain. I just made faces, and the face said, okay, come on. You and I have a special connection. Support the inference that plaintiff believed that the substantial motivating reason for the unlawful entry and related conduct was plaintiff's sex and/or sexual orientation. Now, sometimes, and we all do it, especially lawyers, we tend to be a wordy sort, and I no exception. If you've listened to me, you know I'm wordy. Sometimes we say too much, or we say things that are unnecessary. Because quite frankly, this paragraph could have been written and have been just and strong and effective if they left out the section about Smith's alleged prior statement to him about them having a special connection, supporting the inference, because again, we don't know who left the item in your room, and the door is open too wide for that to have been any number of people. And while nobody, even if nobody doubts that happens to you, you undermine things when you do too much by tossing in something that doesn't need to necessarily be there, at least not in this paragraph, because the claims as it relates specifically to Will and this whole alleged grooming stuff or whatever are still going to be pretty hazy for most, unless you are bringing a whole lot more than what has been stated in the complaint, which wouldn't be unusual. You can still not say everything, because you're going to have an opportunity in court to say more, or, amend your complaint and add more, however you want to do it. It's not like you're putting in every single word that you're going to say, but you're given the big picture. And some people's complaints are far more specific than others. I mean, we've certainly seen complaints that are 70, 80 pages long, sometimes even over 100 pages. This one is just a hot 15. So I just think it's unnecessary. And sometimes, you talk long, you talk wrong. And that's kind of the way I feel about that paragraph. At any rate, plaintiff promptly reported the intrusion to hotel security and defendant's management, filed a written report, all the things that we know that he did. Defendant's actions, including failing to take protective measures and terminating plaintiff in retaliation for reporting potentially sexually violent acts, were substantially motivated by plaintiff's sex and/or sexual orientation, or by defendant's perception thereof. I think that this is a great claim, and part of it is not just because of the sexual orientation or the perception thereof, but remember what I talked about much earlier about this being treated perhaps not as seriously as it would have, as it would have been taken if he was a young woman versus a young man. That is still an action that is substantially motivated by his sex. We often think of these cases as it relates to women, but in this case, it's the same thing. You didn't take this as seriously because of either my sex or because of my perceived sexual orientation. You thought it was like, like, oh, ain't that what y'all do? So either way, I think, even though I didn't like some of the words in that one paragraph, I like this as a good meaty claim that's going to cause Smith's team to have to work a little bit. It's claims like this that are that get you to the settlement table. So I definitely like this one. That's number 5. And finally, number 6. This is sexual harassment. So let's see. I read this earlier, but let's break this down with that. So this is sexual harassment pursuant to California law. It makes it illegal for an employer, and it's pretty much the same everywhere, for an employer, labor organization, employment agency, apprenticeship training program, or any training program. So we know it's any of your jobs, or any other person. So it makes it illegal because of race, religious creed, color, national origin, ancestry, physical disability, mental condition, genetic information, marital status, sex, gender identity, gender expression, age, sexual orientation, reproductive health, decision making. That's not in everybody's sexual harassment statute. That's a great one. Way to go, California. Or veteran or military status, to harass an employee, an applicant, or unpaid intern or volunteer. Not everybody's has that, but that's a good one. Or a person providing services pursuant to contract. So even though they are specifically pointing to the sexual harassment piece in this particular claim, this FEHA government code section 12, was it 12940 J, actually isn't just about sexual harassment. It's all of the things I read, but in this case, they're using it for sexual harassment. I think what's important, although it's a little off topic, but good to know, especially for any young people or even parents looking at this, or just anybody who volunteers as well. Interns and volunteers, so unpaid people, you fall under this statute. Well, you do in California. So I would suggest definitely checking it in your particular state, especially if you feel like you've been treated some kind of way. If you've been treated some kind of way that was inappropriate as it relates to any of the protected classes, and you were like, well, I'm a volunteer or an intern, so they treated me some kind of way, so I'm just going to leave, or I'm going to put up with it, or whatever the case may be. You fall into this situation as well, even as an unpaid intern or volunteer. So that's my public service announcement. But let's move on. Okay. It further states an employer may also be responsible for the acts of non-employees with respect to harassment of employees, applicants, unpaid interns, all the people. So I think so we know that that's important, because you don't want you want to make sure, and this is the law as well, but of course his attorney is stating it, because of course if somebody's like, oh, well, he didn't work for me, or he was just a roadie, or he was just a volunteer. If you were there sort of under my authority or any of those things, you still count. Thank you very much, Shade in the City, for telling people to hit that like and subscribe. Absolutely. And I have not been saying it, but like, comment, and subscribe. I've been taking it for granted that you're reading the bottom of the screen. If you are listening to this in podcast land, which I anticipate will be up tomorrow, I have to get my editor, also known as my son, to get that going, to get that up for me tomorrow. Then we certainly want you to like and comment or give it 4 stars, depending on whether you're listening on Apple or Spotify. Thumbs up, all the things, everywhere you are. Make sure you're doing those things. And believe it or not, we're almost done, guys. We've covered a lot of ground. Okay, so we are still on the sexual harassment claim, and we want to see what that's about. So he talks about being an employee. We know that, based in Los Angeles. We know that that's where he was primarily working and preparing, even though some parts of it, especially the triggering act for sure, happened in Las Vegas. But again, I don't think that's gonna change the venue at all. So an individual broke into his hotel room while he was working. We know that, left a handwritten note. So he's just giving a breakdown of that. Really didn't have to. He said all of that above, but I get it. So this intrusion occurred in a hotel room assigned and arranged by the defendants. Plaintiff made a protected complaint. So that's important, because he did do that. Remember, we liked that particular claim that talked about his action being a protected action. Defendants knew of the conduct of the intruder after it was reported to them and failed to take immediate and appropriate corrective action after plaintiff reported the sexual harassment. And again, we know that it was creepy and weird, and there's no question that it was sexual, bizarrely so, but it was of a sexual nature. He's and by the way, the sexual harassment complaint, of course, if it's ongoing and pervasive in numbers of incidents, it's easier to prove. But it doesn't. You don't have to wait until somebody harasses you 500 times to report it. Once is enough. Okay, plaintiff defendants knew. We talked about that. His complaint regarding the sexual harassment was a substantial motivating reason for the adverse employment action. We talked about Miller's stupidity. Defendant removed plaintiff's previous role. He was harmed. He talked about the harm. He talks about the decision to remove him and the reason why. He doesn't really spell out as much as he did in some of the other claims, the sexual harassment, but I don't think that necessarily knocks out this claim. And again, I don't think that they have to focus on reaching unless he has more about the whole alleged grooming of it all. I think that there is enough with that direct tie, especially if, well, there's two things. One, if they are able to prove that someone connected with the tour put the stuff in his room and combined with Miller's action, I mean, slam dunk, slam dunk, slam dunk. But honestly, even if they aren't able to prove that someone specifically connected to the tour put the stuff in his room, I do think, and it may or may not get him anywhere, but I would certainly make the argument, and I am certain that his counsel is going to make the argument based on what he's written here, that even the way that the situation was handled, it was clear, or certainly the inference can be made and argued, that it was handled the way that it was handled because of either him being a man and or it not being taken seriously because of his sexual orientation or perceived sexual orientation, especially given that the note that was written and the items put in his room not only lended themselves to it being of a sexual nature, but a particularized sexual nature because of that, quote, perceived sexual orientation, unquote. So his prayers for relief. Obviously, a judgment, special, general, and compensatory judgment, punitive damages, reasonable attorney's fees, expert witness fees, litigation fees. So the bottom line is, you want all the money that it's costing you to bring the case. You want all of that, not just your attorney's fees, but whatever they charge for the experts, witnesses, flying, all of that. Any expenses for litigation, special, general, and compensatory damages to, again, compensate you for what you have been through. That includes everything that we talked about, any medical, anything that you bring to talk about the psychological damages. The special damages could also, with special damages, I would imagine in this case, I would argue the reputational harm would be a good area to house that special. The special damages umbrella would be a good place to house reputational harm, especially given that he's in the entertainment industry and just the impact of that, because as I said, it's such an incestuous as such an incestuous industry. Okay, so punitive damages, punish him, period. This is your punishment. We know, like, for instance, with the Cardi B, and speaking of Cardi B, the Stefan Diggs stuff that we're going to get into, we know specifically with the, I guess that's one of the most recent spectacular examples. And also even with the TikTokers, who is it, Brene and Tim and Akira and all of them, that their damages as it relates to medical or mental were actually not very high. I mean, I covered the Cardi B case in particular, the Brene and Chris, when I watch from a distance. We're going to deep dive it here, because I've definitely been gathering notes on it on the break. But speaking, I'll use the Cardi B case as an example because I actually covered that quite extensively. Her damages, her compensatory damages as it relates to her medicals, her mental distress, all of that were actually fairly low because I mean she had the therapist bills. They were what they were. They were like less than $100,000. It might have even been less than $50,000. So the rest of that, damn near $4 million, that was the punitive damages. That was the judge punching Tasha K in the face for, or the court rather, because what's that? Is jury trial? I can't, now it's driving me crazy. I can't even remember. But anyway, that was the court punching her in the face because of not liking her behavior. And the same thing with Brene, Chris, and Tim. I don't recall that. I mean, of course, she got attorney's fees, obviously, but I don't recall her compensatory damages because, again, it would be related to like, medical and psychological, therapy and whatever. I don't recall those being that high at all. Again, it was the punitive. It was because of what was perceived as just the outrageousness of the behavior. It's the punishment. So that caused the that monetary value was like 1.7 million. That's what the bulk of that 1.7 million was. So that's and so the punitive is where you do have to be nervous, because if the trier of fact, whether it's a judge trial or a jury trial, if they think that you are a piece of shit, or that your actions denote those of an entity or person that is a piece of crap, then that punitive is where you get smacked all over the place. And the infamous McDonald's case where that the old woman got all the money for the hot coffee burning her legs, despite hot coffee being by definition hot. Yes, there was certainly testimony about the fact that the coffee was way hotter than what would really be necessary. So there was that. And obviously with the serious burns, she had medical. But again, the punitive in that, if you ever go back on that, and hell, maybe we'll do a deep dive there if we get a little bored with the celebrities and their shenanigans that come up every freaking day. One of the things that was cited in that case, because again, I was around when that happened, was the way that McDonald's, because again, it was as the entity or the owner operators of that particular store. It was the way that she was treated, that they were very callous in how they handled it, the whole oh well of it all, and just kind of kind of thing. For those of you who are listening, I just kind of threw my hand in the air like, have to get out of my face. So that doesn't help if nobody likes you. And in that case, it's, the big bad corporation against the little old lady. And then you have the nerve to not be, like, oh my God, what can we do? How can we help you? Please, please, please let us help you and make you whole. Well, we're going to slam you, especially when we know that you have the money, because again, you are big bad corporation. So that is where we are. And again, lots more cases to talk about, lots more stuff to do, because again, we will deal with the fun stuff. We always do. We definitely have gossip to get into, because you guys know pop culture for the grown and sexy over here. But we got the legal knowledge. We're going to do that. And so we're going to enjoy it. We'll do some nights where you guys can ask me anything, 20 plus years in the field. I know a few things. So we can do that. And of course, award season is upon us. And we love fashion. So we'll get my girl Riri back up here so that we can talk about that as well. For those of you who are listeners of the podcast, you do know that way back in the day when the Real Housewives of Salt Lake City first started, we talked about all the things. We did the deep dives on Mary Cosby. We followed the Jen Shaw case from start to finish and had all the documents and all the things. So I definitely have some opinions as it relates to the cult of Mary Cosby documentary, and kind of a bit of a different take, I think, on some of the things that were discussed, and if it's a cult, when that really happened versus when the documentary and others think that it happened. And again, if you listen to some of my old episodes, you definitely know my thoughts about that. So we are certainly going to get into that as well. So stay tuned. It is just beginning. I hope you enjoyed the reissue of the Starting Over series, beginning with that episode. And we are definitely going to have the next part. I'm sorry, I said starting over, didn't I? The starting after series. And we are definitely going to have the next part of that this week because I did leave you on a bit of a cliffhanger. So as we finish my starting after story, I look forward to bringing you many other people's starting after story as we move towards a book all about starting after. So lots of great things coming with this season of Let's Be Honest with Just Johnda and the mini series we have going on, and some wonderful collaborations that are growing from this as well. Once again, shout out to my girl Treese from Shade in the City. You will see her in if you look at the live chat, if you scroll over to see that. So make sure you follow her with Shade in the City. I've certainly had the pleasure of being on her show a number of times, especially as we talk about one of our favorite shows, Beyond the Gates. And so lots more to come, and collaborations to come, and we're just going to have a great time. So thank you so much for being here. And my motto has not changed. If you are thinking about it, talking about it, or want to hear about it, chances are I'm thinking about it, want to talk about it, and I've heard about it too. So let's be honest together. Good night.